It's Brian Wilson, Larry O'Connor taking some time off. We're joined today by Crystal Wright.
Hello, hello, hello.
Huge day for the rule of law here.
This is a big blow to Obamacare.
This decision ultimately could gut and really cut the heart out of Obamacare.
If this ruling stays in place, it would essentially obliterate Obamacare.
All of the people that got subsidies at healthcare.gov are essentially in violation of the law.
Going forward, it's going to be chaos.
Or is it? It seems to be now an open question. Sam Kazman from the Competitive Enterprise Institute is on the line now. Good morning to you, Sam.
Hi, good morning.
All right, so the reason I say or is it is because there was one ruling that came down from the U.S. Court of Appeals, and then there was another ruling that came down from an appeals court in Richmond that seemed to be exactly in the opposite direction. So because you're an expert and because I'm very confused, as many people are, about what these two rulings mean, help us sort it all out.
Well, the basic issue here is that when Congress drew up the Obamacare statute, it drew a distinction between health insurance exchanges sponsored by the states and then what would happen in states that decided not to set up those exchanges. We call them the refusenic states. In that case, the feds would come in their place and set one up. But they only made the health insurance exchanges set up by participating states eligible for the subsidies. And they figured, hey, we're offering these subsidies to every state. What state in its right mind is going to refuse? Lo and behold, about 36 states have chosen to be refusing.
They didn't want to do that. Okay.
That's right. And so the IRS comes along, and it has the task of implementing the law, passing, administering regulations, and so forth. And their regulation simply obliterates that distinction. And so the real legal issue here is, did the IRS have any authority to do what it did? And I think the correct view, the one taken in the D.C. Circuit, is that no, agencies implement the law, but they do not rewrite it. And here you had the IRS doing exactly that.
All right, so now the second ruling that came down looked at it in a different way, and there have been other courts that looked at it like the second court did. Am I correct?
That's right, but these are the only two circuit court decisions on the merits here, that is at the appellate level. And the second court, namely the Fourth Circuit out of Richmond, said, we think the statute is ambiguous, and when you've got ambiguity, it's the agency's job to resolve that ambiguity, and so they went along with the IRS. But that court did admit it was a very close call between the two arguments, and so just looking at it at that level, I think the D.C. Circuit decision is quite a bit stronger. But obviously you've got a split between the circuits. Ironically, these are cases both of which CI itself is involved, and they came down within an hour or two of each other. I suspect that's a Guinness Book of Record, but they don't seem to keep track of that.
Yeah, Sam, hey, it's Crystal. Don't you think once again this is an example of the president and his administration playing fast and loose with Obamacare? I mean, we saw the delays. And also, I guess that my second question is, doesn't this turn the individual mandate upside down and really, threaten for this whole law to fall apart? If it goes to the Supreme Court, which it seems like it will, and they decide, hey, wait a minute, this wasn't in the law.
What that does really is it, in a sense, puts the debate back into the states themselves, because states can choose whether to be refuseniks or whether to participate. And so you're going to have a state-by-state political debate over participating, and you may well have a congressional re-examination of Obamacare as well, the sort of thing that the House Republicans have tried in extreme senses and failed, now may actually spread to both chambers and may well have an impact on the November elections. But I think the more important thing is that this has huge implications for the rule of law, because if you've got an activist White House and agencies operating under that, if they think they can simply rewrite regulations to push an agenda, that is a very, very dangerous violation of separation of powers. And so, frankly, I'm very happy to see that, at least as far as the D.C. Circuit goes, it was the framers, the founders of this country that actually have the last word here.
Well, I want to go back to what you said about the states. I don't understand how it would be put back in the states because there's only 36 states that have their own exchanges, and according to the Supreme Court ruling upholding Obamacare, and if you could explain this a little bit, if the states chose not to expand, and then folks go into the federally subsidized, they go into healthcare.gov to get the exchanges right from the federal government. According to one of the rulings, right, they couldn't be. Wouldn't it go to the Supreme Court to determine whether or not the IRS could indeed subsidize, through their interpretation of law, subsidize those people who didn't have state exchanges to go into?
Well, you're certainly right. Well, the split between the circuits will be resolved, and
okay.
I think the likeliest way in which it will be resolved is through the Supreme Court. There are some other scenarios that go differently, but I think that's ultimately where this will end up.
All right, given the makeup of the Supreme Court as we know it, give me your sense of how they're likely. I mean, is it going to be one of these very close 5-4 decisions? Do you have some sense, given past rulings from the Supreme Court, how they might go in this particular matter?
I think it's very tough to say. I do think, though, that the principle that statutes are to be understood in terms of what Congress actually wrote down rather than what some congressional leaders had in their hearts, is a very important one that really does transcend any political sympathies. And so I just don't think you can decide how this will go based on which party was in power when one or another Supreme Court justice joined the bench. I think you've got an overriding principle here, and I just don't think there's any predicting. But frankly, I think the better argument, obviously you know where I'm coming from, is the one that the D.C. Circuit accepted.
Mm-hmm. So the overriding principle here being that what the law actually says is more important than what the legislators intended.
Yeah, and it's easy to say legislative intent, but there's no, if you've got a law as massive as Obamacare, passed in such haste as Obamacare, there are numerous intents, and each of those intentions have to be filtered through a political process that involves a lot of log rolling and compromises. At the end of the day, there's no way to fish out any one overriding principle. And so the D.C. Circuit did what it should have, namely it focused not on talk of intentions, really, but on the text itself. Now, some people say, well, the text they focused on was this typo that no one really paid attention to, and that's nonsense. The provision here that talked about state-sponsored health exchanges appeared in the law 7 times. So this was not a typo.
It's very clear what they were talking about, right?
Yeah, and for those who argue it's a typo, they have a lot to learn both about the law and about typography.
We're going to leave it right there. Sam Kazman with the Competitive Enterprise Institute, thank you for joining us and helping us understand these complicated split decisions. It does sound very interesting. We appreciate you helping us out.
Thank you. Bye.